I'd like to begin as well by also acknowledging the traditional owners of the lands that we're meeting on today, and thank you to Kevin and to Peter for already speaking. I'm probably not going to speak as long. I'm going to make sure that we have some time for questions, because I think between all the things that have been covered, there might be things that you'd like to ask about. Look, thank you for allowing me the opportunity to speak to you today. If you don't already know me, I'm Laurelea McGregor. I'm acting as the National Judicial Registrar for Native Title at the Federal Court. I think it was mentioned before, I've been at the court now for a little over 7 years, and it's really thinking about what I was going to talk about today. It's really my intention to outline some of the observations that I can make about how the work of expert anthropologists has really impacted on the various ways that we approach native title dispute resolution in the court. I think there's a lot of focus on sometimes the negative aspects of being involved in court proceedings, and I'm not going to take away from that because I'm not the one who's been on the witness stand, but I think there are other benefits and there are other positives that arise through the involvement of anthropologists that potentially are not talked about very often, so I'm hoping to cover some of those things. I had understood that this conference would be potentially a bit of a mix of some very seasoned anthropologists and maybe people that are a bit less experienced in actually acting as expert anthropologists in the court. I know some of you are very well versed in the way experts are used in court, and some of you probably aren't yet. And I know that some of you have spent quite a bit of time in expert conferences and other things, and potentially even with me. But I'm going to outline some of those processes because I think it's useful to sometimes demystify some of the things that happen in the court processes that you probably don't know about if you're not actively involved in them yourself. I hope that providing some perspective on what I've observed, that insight might provide insight into how anthropological opinions, and particularly those expert opinions that the court is looking for, are used not just when a judge is trying to make a decision, but sometimes in other more mediated processes where we look to utilise that expert opinion to try and maybe break down some barriers between whether it's state or whether it's inter or intra-Indigenous disputes going on before the court. I think it's really important that I identify that the pathways when I think about disputes in resolution in native title proceedings, native title has been around a long time now, but what I'm thinking about is not just the resolution of native title claims, it's also about compensation claims, it's also about RNTBC disputes that are starting to come before the court, and those might be things that relate to rules, they might be relating to decision-making processes, they might be relating to membership, but in all of those areas there has been and probably will continue to be a role for expert anthropology in those discussions. And it's even now the case that there are other areas of the court practice where expert anthropologists are being used where Indigenous issues are coming to light before the court. One of them that we're seeing them a little bit more is class actions. So the use of experts who specialise in native title or have that background is starting to expand, and I'm not necessarily sure that we've seen the last of where that's going to go. There's three things that I really wanted to cover in this presentation, and one was about the value and importance of the independent expert to the court, and the next one is about the expert opinions in the course of evidence in a contested hearing, how they participate as experts in conferences of experts, but also how expert evidence is heard in the courtroom. And the third one I wanted to talk about was how expert opinions are used in the course of experts' conferrals in mediation. So going to the first one, I think everyone's aware, if they've been an expert, that you have to adhere to the Federal Court's expert witness guidelines. And I can encourage you to read them, and I have no intention of going through them right now. I think if you're going to be an expert witness, you can read them. And if you're being briefed to be an expert witness, you're going to have received them. And if you've been involved in a process in the court where the court is running it, you're going to have been sent them. So I'm not intending on going through all of those, but I do think it is an important document to read if you are asked to be an expert witness. I do want to really focus on or acknowledge, though, that the real importance of the expert witness guidelines from my perspective is that at the core, everyone who's connected to a court case is there to provide assistance to the court and to ensure that the court, meaning a judge or a delegated decision maker, is able to make decisions with the best possible information at hand. And I think as researchers of any kind, you've probably heard lawyers say that their first duty is to the court. and that's actually above and beyond their client. That's their obligation. And it doesn't mean that they don't advocate for their client, of course they do, but their most important responsibility as a barrister or a solicitor is to assist the court when they go into the courtroom. And I think that when I think about the expert witnesses, I think about it being a bit the same. So, excuse me, their obligation as expert witnesses is to come to the court and provide an expert opinion in a way that is independent and impartial. And I think that that's a really important thing for everybody to remember, because that's not an easy thing to do. And I think in practice it can look quite different. So when you have an expert witness on the stand, it can look like somebody sitting there and they have a really clear and precise view, and they have a researched opinion that they feel very certain about and they're able to express. But it's also the case that sometimes an expert witness can sit on the stand and they can say, I've done all the research I can and I can't come to a concluded view. And there's lots of variations in between those things, but I think the most important part is the fact that that researcher, as the expert anthropologist in most cases, is able to sit there and express that view. And it's very important, I think, to the court and to the decision makers that they hear that independent view. When you're sitting in the courtroom, I shouldn't laugh because I haven't had to sit on the witness stand, but it's obviously a terrifying and frightening experience for any expert witness in any area. But I think it's well acknowledged that the independence of expert anthropologists is a very tricky thing. It's very difficult because you are, by your nature, going out and interviewing people. You're interviewing humans and you're talking to people. You have going to need to form relationships with those people. You're going to need to sit down and talk to them about very personal things. And then sometimes you have to come into a courtroom as an independent expert and say things that may be contrary to what people have said to you. And I think it's acknowledged, even if it can't be written in judgments. I think everybody who sits in native title practice in a courtroom acknowledges the difficulty that puts on expert witnesses. And it's very different to an expert witness who might come into the court and, be a forensic accountant. I mean, it's very depersonalised. I think there is an acknowledgement that an expert witness in anthropology and in native title proceedings, it's a tricky place to be. But I don't think it should be a reason not to be somebody who comes and fulfills that role, because it's very important. I think that the court is well aware, and it's well documented, that there has been such a lot of forced removal and violent treatment of generations of Aboriginal people, Torres Strait Islander people, that it's really meant that there has been an impact on generational knowledge in some places. And it can be very difficult because expert anthropologists then need to play a role sometimes in forming a bridge or a gap between the knowledge that people have today who talk to us, who turn up as witnesses, and the knowledge that might exist from a time, we say before sovereignty as lawyers, but what it really is so many years ago. And that gap, native title has been around for more than 30 years, so the gap in time between people who used to be able to say, I was here, I remember people coming, like Kevin talked about, that evidence is much harder to get from a witness now sitting on the stand. We're just so much further down the road that knowledge and generational information is just not the same. And I think the court acknowledges and knows that bridging of that gap, sometimes anthropologists are the ones who are able to assist the court to understand that gap. But I do appreciate that that's probably a very difficult task for anthropologists to do on the witness stand. Something I wanted to also, reiterate is that it's really important that experts are available to provide an opinion that's free of interference or expectation from legal representatives. I think experts are briefed, and it can be the best of intentions, but when research is conducted, the research may not turn up the things that lawyers or legal practitioners are hoping that it will. And that can create situations where expert witnesses are going to be saying things that are potentially not what a legal team would prefer they're saying. And although that's difficult, that's a really important role of an expert witness, not just in native title, but any expert witness. So it's important that that independence and that research and that is maintained if you do end up on the witness stand. Another thing I wanted to talk about was conferences of experts. So I think everyone's heard about conferences of experts, but I think if you haven't been directly involved in one, you might not really know what they mean or what happens in them. So when an expert files an expert report in a court proceeding, the parties who are in that contested pathway are going to then have their experts involved in an expert conference. So this is where experts who filed the reports come, they participate in a conference. Usually there's a list of questions and the statement or questions that have been put to the expert have been agreed by the parties, often settled by the registrar, and that conference is conducted in a confidential setting. So the experts attend and they're able to discuss, debate, exchange thoughts on a confidential basis. So it might go for 2 or 3 days, and at the end of that time, they then need to turn up and they need to then write a report that's filed in the proceedings. So out of that time that they spend together, there's a list of questions or statements pre-organised, usually, not usually amended too much during the course of a conference, but at that report at the end of the day is filed. And the purpose of that report, I think, is again, it becomes really important, and it becomes really important because that becomes a tool for the judge and the parties to start to narrow the cost and expense of the court hearing, to work out what do they really need to work on. So that report will usually be something that identifies things that experts agree on and things that they don't agree on. And most importantly, when they don't agree, why they don't agree. And that becomes the focus often of the next phase of a hearing process. These conferences, for anyone who's been in them, they can be very stressful and they're very time pressured, and everyone involved in the litigation process is waiting for these conference records to be completed so that they, as preparation for their next phase as lawyers or even the judge, can start to prepare, because that's what they're waiting for. So I totally acknowledge that they are extremely stressful times, but they're also very valuable to the court process. So that report, that process of limiting the issues in dispute, hopefully, or at least clarifying the issues in dispute, again, at that point, that expert anthropologist or those that are involved in that, it's really important. And I know that at the end of the day, sometimes there's a lot of criticism in judgments of a lot of witnesses, including experts. But I still think it's important to remember that there's a lot of parts of this process that that role of the expert witness is really, really valuable. The last thing I wanted to talk about was expert conferrals in mediation. So in recent years, particularly in relation to inter or intra-Indigenous disputes, we've started to see an increase in the use of expert conferrals in mediation. So this is where we get maybe 2 or more experts to come along, and in the context of a confidential mediation, they sit together and they discuss the same sorts of things as might be in that conference of experts that we have in the litigated proceeding. So there might be a list of questions or statements that those experts will consider. And at the end of that, it's a paper that's produced that's confidential. So the major difference is that it's a report that is able to be just provided to the parties, just used for further mediation. Often they're conducted earlier than is the case that a final report has been produced. So it's aimed at being cost effective, I think, is one of the benefits that can arise, but it's also less formal. So it's an opportunity for anthropologists as experts to inform each other of their opinion, to inform their lawyers of their opinion, and it's an early opportunity for claimants in processes, whether it's in a native title claim or another dispute, to see what might happen on the witness stand, what their independent expert might say to the court, and allow them to get some advice about what that might mean as the outcome when the decision maker has to make a decision. Those processes have been, I think, more increasingly used with intra-Indigenous disputes, more so than when we have a dispute between a native title claimant group and a government agency. Are they effective? I think that varies. One thing that is effective my observation is effective is the fact that often those conferences allow space for questions to be asked that claimants or people who are in the dispute, whatever it is, want asked. So there's a little bit more freedom for the people who are involved in the dispute to frame the questions that they want to hear answers to. And I think that's very valuable to the process, where we want to have Indigenous people who are in the middle of a dispute to be able to be at the front of trying to work through issues that are preventing a resolution. So I think that's one of the things that I've witnessed in that space that is quite different to the conferrals that happen for the purpose of a litigated proceeding. There are often questions that are quite specific and maybe personal to a particular family or a particular issue, which can be really firmly put to the experts, and claimants can get that response. And that sometimes can be quite important in moving a dispute forward. The ownership of that process is quite important. So when we talk about the finalisation of the report in that space, the finalisation of that report is, as I said, confidential. It goes to the mediation parties. The conferral is still only between experts and the registrar. It's not involving legal representatives. And it has a few benefits. I think I touched on it before. The lawyers have the opportunity to look at it and go, well, maybe I need to give some advice. Everybody gets a sense of what their experts think, and potentially it's different to what they expect they think. It also gives an opportunity for claimants to get a bit of a reality check about what their experts going to say. I'm not sure how easy it is, having not been an expert, how easy it is to go back in and do more research after you've been involved in one of those processes, and somebody you've had to potentially share an opinion that might be one that is not favourable to people that you've been briefed to represent. There's probably some difficult questions and conversations that arise out of that. I don't think I'm going to say too much more, because I think there's a lot of questions that everyone will have for all of the presentations. But I guess my message, or the thing that I wanted to really focus on, was thinking about really whether you're a seasoned and experienced expert in the court, or whether you haven't yet taken that step to being an expert witness in the court. I think there's so many processes and pathways in the court now to resolving disputes that the role of the expert in those processes is so much more than what you read in a judgment, where it may feel as though people are being criticised. I think that it's really important to know that. So if you're looking at, there's a lot of, I understand that there's a lot of fear in being involved and being an expert witness, and I think that's probably not without good reason. Like I said, I've never been the expert on the witness stand being asked questions, so I mean, kudos to the people who do it. But I still think there's a lot of other roles in the dispute resolution process where particularly expert anthropologists have a role to play, and it's really important that you do play that role, and it's very important that you are independent in the way that you approach that. And it is really valuable to so many aspects of the dispute resolution process, and I think when it's used properly, there is a real value to being able to support Indigenous people and Torres Strait Islanders, Aboriginal people, everybody that's coming to the court in the native title space across all of those disputes, to focus and try to resolve their disputes in a way that is better than ending up in the courtroom. So that's really all I wanted to say. Hand back over to Wendy.